by Zoom or in person, make evaluation.
Say the words, I understand.
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. Because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. I will adjourn it to 9 a.m.
Your Honor.
or I will. Do not interrupt me.
I can object to
Do
that.
not interrupt. Do not. One more time. You're going. Court does call the case of the people versus Daniel Magoo.
That's the one for the people.
Morning. Daniel Magoo.
You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor. So I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry.
Um,
I'm here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
Yes.
this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until
Suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained. And because of that, any violations that I could have possibly said that could impede my my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened, I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it, your motion's denied.
Okay. Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. Nope.
Have you asked them, how do I get discovery?
No, I will be doing that.
Did you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay. Well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. You may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor.
All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could much go south for you.
Yeah, I understand.
Not be good, but I'll let you think about that. That's your call.
All right.
Court's in recess. Court recalls case People versus Daniel McGraw.
Pass along to the people.
In Your Honor.
State your name.
Daniel Magoo.
All right.
Your Honor, when the court passed this case, and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand delivered it to the defendant, as well as handing the copy to the court. If I may just respond to the record.
Yes.
Thank you. So, this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that, as the court is well aware depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No, motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely, Art. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people executed a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within.
I really would be
grasp.
objective that the defendant showing anything to the court that he has not disclosed to the people.
So, given that I do have FOIA on my CAD records for the dispatch record of police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night and
So you want his medical records?
I want to first of all subpoena him to get his witness statement on record officially, and I would also like his records due to the nature of why they.
I'm not going to order. I mean, that is. I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that motion.
Yeah, a lot of my civil procedures I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
And this
I'll
is
try to
criminal
follow
proceedings.
COAs then. Thank you for
So-
your guidance.
Yeah, so you might want to start there.
Okay.
Okay,
So that 3 is denied.
huh?
3 is denied, Your Honor.
The whole motion's denied, yes,
Thank you.
all three parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process that's available to him.
That's it.
Understood.
Okay. Number 5 was that the defendant is requesting the report produce all audio or video recordings. I said he should go through the discovery process. That's that motion at this point. Like, don't.
It's denied.
Thank you.
You can
Number
get
6,
to him.
the people, I'm not exactly sure. There's a motion to seal statements.
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before, after.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience, as I was not
What does that mean?
well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly
You
afterwards.
have to file a motion, you'd have to lay out specifics as to how and or another, any statement that you made, which it doesn't sound to me like was the subject matter of necessarily an custodial interrogation, but it doesn't really matter. You're gonna need to lay out all the elements of that before I would rule on that. But in its form, as it sits right now, that motion's denied without prejudice.
Thank you, Your Honor. My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Okay. I don't have any response to that, really, beyond the fact that it seems that these are videos the defendant has, and that he hasn't received any videos from my office yet, so I don't see how
I have
he can
video.
respond to any piece of this.
I have videos, both FOIA requested from the Ypsilanti County Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure, that's what I was, yeah.
So this last one, what are you gonna do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work a way it doesn't.
Maybe that's a disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have hearing, but I do have an issue if he's trying to say that he can't do anything until we subpoena somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in a criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really all.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Aaron.
Okay, so what are we gonna do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm gonna tell you something, sir. I'm not gonna sit here listening to frivolous motions.
Okay.
I'm just not gonna do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some, for adjournment in order to review the discovery materials I produced from my FOIA,
That what?
that I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review the
What does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them, Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor. I mean,
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
thank you, Your Honor.
And Your Honor, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th, 2024, 9 a.m. Court recalls the case, People State of Michigan versus Daniel McGrew.
Just goes with.
State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there. You recognize
Recognize.
that. You understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be,
Your Honor,
you have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. Because you're my friend and you.
Good afternoon, Your Honor. Daniel Magoo. Here in Dewey Juris.
All right. So on this matter, I was apprising you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your Honor, if we could talk
I'm
about
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will, do not interrupt me.
I can object to
Do
that date.
not interrupt. Do not. One more time, you're going. I've given you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may leave
violation.
now.
Let's go. Let's go.
I have a right to
You
a
may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
And I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations.
do
that
you
need-
wish to be represented by an attorney,
You
sir?
take an oath to defend the Constitution of the United States of
Then
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my courtroom. Court does call the case of the people state of Michigan versus Daniel Magoo.
Your Honor, after Lonnie, but people.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals for the state of Michigan
Yes.
that was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed include, appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my, what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue. Court does call the case of People versus Daniel Magoo.
Actually, let me.
Danny Magoo.
Ready for preliminary examination, or at least to deal with this motions? What are we doing?
Yeah, would the court be so kind as to make the self-representation inquiry? And
Yes.
perhaps we could look at the motion first.
Ms. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then the attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you, Your Honor.
What are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note, I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office, so that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of?
I believe it's the 911 call that brought the officers to the scene, but it would not be an exhibit that people plan on playing at the preliminary examination.
All right.
I would like then to motion for a preliminary examination to get the officers in here on the record, then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
No, Your Honor.
All right.
At this time.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. So the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate. Does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for the, Your Honor.
Yes. So preliminary examination will be set January 21st, 2025, 9 a.m. before me. That's in person. Defendant's bond with conditions is continued.
You know what?
What?
I'm gonna pass this case and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
Say something, but she was in school.
Okay. No, sir, that picture is not going to happen that way. You're not going to sit up there and display things to the court that way.
Okay, I asked first. I'm sorry. I've mentioned her a lot, so I just wanted you to see her.
All right, let's deal with your motion first, Mr. Kemp.
Your Honor, did you get the evidence package, the exhibit evidence? I asked the girls when I walked in. Nice ladies up front.
I have these picture exhibits. I don't know if Ms. Dornbush has them or not, but
No.
I have them.
Okay, you do have them?
Your Honor, I do not have them, just so the court is aware.
All right.
I thought they were both sent because I have a double thing where you could send group, and I sent them. Your Honor, I just with due process, the most important thing is being heard, and I haven't been able to be heard yet and state my case and defending myself with all these accusations. And you know, that's why I know I missed the trial, but there's all kinds of reasons for it. I've met all the demands of the court. If you remember, I was before you for 4 or 5 months in a row dealing with the rent, and we made decisions, and I lived up to the demands and so on and so forth. So I did you read the motion where I gave you?
I have read everything
Okay.
that comes in this.
All right. I didn't know. I'm just, I want to have a trial.
Sir, I gave you that opportunity to have a trial on October 30th, and you failed to appear.
I know, but fails to appear sometimes happens. Can I read something to you, Your Honor? This is all diversion programs and sent down by the Attorney General to try and help tenant landlord disputes. That a judge could take a proactive role in the hearing by ensuring that both parties know.
What are you reading from?
It's recommendations from, we never even got a chance to talk or settle. I mean, we had a last settlement conference, but we didn't talk about anything. And before that, the attorney and the landlord, the property manager kept me from talking to him. We couldn't even try and settle. And throughout the whole thing, all the legal stuff that I read is that you try and work it out before the eviction case. And also I have, this is for sure a retaliatory eviction, and you wouldn't even let me speak on it the one time I brought it up because.
Sir, you know what?
What? If you give me a trial, Your Honor, did you read the character references my neighbor sent you?
Do not.
The Mitchell.
Do not come here
What?
at this hour questioning me
I'm not.
about what you think I haven't read. I have just told you that I read everything in the file.
I apologize.
Do not come here before me, because all of these people have been sitting here, they've been here, and tell me ever that I won't give somebody an opportunity to be heard. Do not insult this court that way. Do not insult me that way. Now, if you want to start your argument again, you may, but you will not sit here and impugn the character of this court or of me with regard to listening to tenants and landlords regarding these proceedings. And you will not attempt to try to school me with some literature as to how to handle a case. I have been doing, you know what?
What?
I'm gonna pass this case and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
I'm confused, Your Honor, please. I didn't say it was you. I said due process. That's all I said.
Have a seat.
I wasn't saying anything.
Have a seat and keep your mouth closed. You throw something down again, we're gonna have a problem. Will you throw something down again, we're gonna have a problem.
Sorry.
Retry this. Court recalls the case of River Ridge versus Timothy Kelly. This is your motion to set aside the default judgment. There are
Yes.
two parts to the setting aside of a default judgment before you start going on. The first part is that you have to have good cause for failure to appear. State every reason for your good cause for failure to appear for the trial.
Oh, you want me to state it now?
I asked the question.
Okay, I'm sorry. I thought you were making a statement. Well, as I iterated in the motion, that one, I don't have transportation. It's very hard to get it. I don't have the money for an Uber or a taxi or any of that. If you recall, I told you, for one of the hearings, I rode my bike 30 miles round trip. So it's not that I wasn't trying to get here. And I also, right from the beginning, everything I've told you has been the truth. I mean, in the beginning of we had trouble with the rent. I told you that I was also going through litigation with a friend of the court. And as a father, that's a very hard thing to figure out and such. So that's one of the reasons was my daughter called me that night. She had an emergency and I had to take care of it. And she was with me the next day, the trial day. And
we received no notification or phone call from you indicating that there was some delay or some reason why you couldn't be here that day. Is there a reason why you didn't call the court?
Yes, and I'll tell you, that week I had dropped my phone and it broke and I had no way to call anybody. I didn't have any way to get any of my trial stuff out. I couldn't access anything. I didn't have the money to buy another phone. So for 4 days, 5 days there, I was in purgatory, so to speak, without being able to communicate, without being able to get anything off the phone pertaining to the trial or this case. And that's the truth.
You mean you couldn't have found a place to call from?
Pardon me?
You couldn't have found a place to call the court from?
Yes, well, I was in the middle of this. Look at my child. I don't want to put it on record yet because has to do with some serious things going on with her safety wise. So, and I didn't know, it's very hard I don't want to, can I ask you a question about the trial? I mean, I don't want you to think I'm questioning your judgment, but I'm confused about why it was set on to the bench when I demanded a jury trial way back.
We have already gone through this. You failed to comply with the escrow order. Plaintiff was entitled to a trial as to the issue of possession, an immediate trial. I set it out a few days. We have been through this. I'm not relitigating everything, nor answering all of the questions that I've answered for you in the past, Mr. Kelly. I'm just not doing it.
I don't recall us talking about whether it was going to be a bench or a jury. Honest, Your Honor. And
Your Honor, I can state the exact date that this was addressed because I specifically emailed the court to clarify if the jury was waived and was able to verify. So I can remind the court the exact date that conversation happened.
I thought at that time that it was
I'm not going back over this.
Your Honor, if you would listen if I could cross-examine witnesses and bring my witnesses in, you'd see a different light on this, I swear. I haven't been able to present anything. You don't, I mean, may I ask you another question that I don't get? I'm not questioning you, but I wasn't there and I don't understand how it came to the trespass and the witnesses that I can't go around them. What was said that you think I'm a danger to the community?
It wasn't an issue of you necessarily being a danger to the community. They were trespassing you after the writ would issue. It's as simple as that.
Okay, well, I mean, those were a couple on the list were friends. I mean, I get along with Kevin, and so I didn't understand why I was out, but it was a good reason. I want you to know the facts of the case. That's all.
The second thing is that you have to state to the court a meritorious defense. Please state your meritorious defenses, Mr. Kelly.
Well, can you help me out with the meaning of that more?
No.
No? Okay. Well, I know have a right to counsel, but all the resources are used up. I have tried for since this case began to get some help from the state and all the resources that are listed, and they're all filled up. I think it's hard to even express because I'm afraid I'll offend you. And
sir, do not try to blame me.
I'm not blaming you
this
at all.
You just need to say what you're going to say.
Okay, well,
I don't think that there's anybody that comes before this court that would at all indicate I don't listen. I may not agree with you, but I will always listen. So don't try to put it, poor me.
No.
Somehow this judge won't listen to me.
I'm not.
Say what you have to say, and then I will make my decision.
Well, I had all kinds of things written down. I started to read it, and you said, "Don't read that to me." Well, I don't know how to present. Can we go over the evidence? May we do that? I marked all the.
Your Honor, I would object. I've not seen this evidence that Mr. Kelly is referring to. It certainly wasn't attached to the motion that I received. I don't know when it was filed with the court, but I've not seen this evidence to be able to comment, to be able to prepare any sort of response to it.
It pertains to my oral argument already on the record, Your Honor.
I'm going to sustain her objection. You can't come here with new things expecting for the opposing side to respond to them.
Well, I was going to fill out.
It doesn't work that way.
Okay. I was going to fill out an amendment to the motion, but I've been up all week, all night trying to just get the proper paperwork into you and do it all right. It's not easy being 95% of us tenants don't have lawyers. We're pro se. So, I don't know where to get any help as far as the legal, but she has been able to bring the list of the original offenses. She's added on to that throughout the trial. The plaintiff has. I mean, now my dogs, first it was just 4 items. And she's brought up my dog. So she's added on without. So I'm just confused about the way to present evidence, I guess. She brought up my daughter missing a day of school. Where did that come from? I mean, all of those have been.
I didn't mention his daughter at all, Your Honor. I'm sorry.
It's in the transcripts. I can't pull it up right now, but it's there because it bothered me. Honestly. I mean, I don't know how to present to you. Why don't I get to present the retaliation defense? You haven't listened to what happened there.
I need meritorious defenses you have to this claim.
You can't tell me what, may I look the word up in my phone?
If you can do it quickly, you can go ahead and do it quickly.
Never mind. Okay.
No, go ahead and look it up.
I don't think.
Your Honor, Mr. Kelly is retrieving his phone. I just want to make the court aware that I would like an opportunity to respond to.
Oh, absolutely. As soon as we can get there.
What's the word, Your Honor?
Meritorious.
Meritorious. Could you spell it for me?
No.
Okay. See.
You
Oh,
filed the motion.
yeah, probably should have paid attention to that.
Yeah.
Well, it's hard. I've been reading everything in the law. It's the only way I can do anything. And there's a lot to take in, Your Honor. The delay, suspension of an act. Oh, okay, I know. I did read that. That's kind of like what they did for COVID with the money. Do I have that right? Sorry.
I don't know what you're talking about.
Well,
I have no idea.
is
what
it
that
moratorium? I'm sorry. Okay. My defense is that I just want to be heard. And I didn't say that you did anything wrong to make that not happen. But with reading all the stuff in the legal that you have to read if you're pro se, I'm not an attorney, but I'm starting to at least learn some of the laws between tenant and landlord, and everything I read is the land of America is trying to the courts handed down by the Attorney General and the Supreme Court on helping the litigants, especially the tenants, because they're the ones that are come to you with no resources as far as money for an attorney or any of that. And the landlords always have the best attorneys. Like I said, 95% of us are pro se. So all I can do, and I told you an attorney called from Michigan Legal Help, but he just left a message and never got back to me. And so I have to read on these motions and read on the appeals or read on how to go about a defense. And when I present
No, come back. Okay. Okay. No, I was gonna make, I think you should stay too. Go ahead.
when I'm trying to present the retaliatory eviction, there's all kinds of writings on that in the law. So it must be something that happens in court or they wouldn't have it in there, correct? I mean, I'm not a bad person. I want you to know the truth, Your Honor.
I'm not saying you're a bad person. Miss Lee, you have arisen. Is there a reason?
I'm sorry, Your Honor. I did want to corroborate Mr. Kelly's account. He did get in touch with our hotline, our housing intake line. We have been trying to give him advice over the phone, but we do not have the resources to represent him. If you would like me to sit with Mr. Kelly for a bit and try to assist him a little bit further, I'm happy to do that.
Okay. If you're willing to do that, Ms. Dornbush, I'm sorry to hold up your evening, but I will allow it to happen because I'm probably one of the most unfair judges I've ever met, but I'm going to try to be fair. Mr. Kelly, can I step away from the podium?
May I give you a compliment, please, Your Honor?
No,
okay.
Do not give me a compliment. Do not say anything to me at this time.
All right.
I'm going to handle Mr. Fink's case as Ms. Dornbush. Sooner or later, you'll be able to go home.
Okay.
She's going to be mad at me.
I would never dare.
I tried. River Ridge versus Timothy Kelly. If Ms. Dornbush.
I am still here, Judge. Yeah.
I called the case. What are we doing?
Well, Your Honor, as far as what you asked me about the defense, I just want to make a notation at the bottom. It says, upon information relief, resident has failed to remedy the violations after being given an opportunity to cure. Thus, grounds for termination exist. I did cure all of them at the time they asked. Every time they ever asked, I always met their demand, whether I liked it or not. So I would like an opportunity to go to trial and defend this and show you that. And as far as any verbal abuse, I put in one of my letters that, or one of my motions that somewhere there's a phone call of that, because it was a three-way conversation, and I didn't know if I needed to look it up or not. But as far as the upon information, belief, and all those lists, please, I deny them, and I can go one by one if you want. I'd just like the opportunity to show you and cross-examine witnesses if there are any, trying to accuse me of this. I adamantly deny most of what's on here. I mean, there was the car, we talked about it, on the grass, but that was during the settlement conference. During what I was just trying to explain to you is that's not how it was. It says parking on the lawn on or about. That car was on the lawn for about 3 months, and then she asked me to move it to the drive. We pushed it to the drive, and then it finally got towed 3 months later for expired plates, because the car wasn't running but it had legal plates up until that point. So that's all I was trying to explain that one day about the car when, the final settlement conference. I wasn't disputing that at one point it was on the lawn, but it's kind of, and I don't know how that works, but I do have witnesses for most of these to dispute them. And I don't know if you have that in front of you, but doesn't that read like if the cure was given, that there wouldn't be grounds for termination, or am I reading that wrong? Because I did cure everything they've ever asked me to do as far as moving.
All right, Ms. Dornbush, your response.
Thank you.
Oh,
Your
I'm sorry, I don't have.
Go ahead.
I'm waiting for Mr. Kelly to get his hearing device.
Thank you.
Your Honor, at the outset, when Mr. Kelly first began speaking, he made a statement that he has complied with all demands of the court. And I want to first address that statement because that's absolutely false. Mr. Kelly has not complied with all the demands of the court because he was ordered to do several things early on and he did not do any of them timely. Most recently, he did not pay the full October rent into escrow. He did not pay November rent into escrow. He did not pay rent into escrow with the motion that he filed, even though he checked the box stating that he did. He made a statement, Your Honor, that there was no opportunity to settle this. That is also false because Mr. Kelly and I had a very lengthy conversation back in August, at which time we did attempt to settle this, but the settlement offer that I was authorized to make was not something that Mr. Kelly was satisfied with. The only settlement that Mr. Kelly wants is an agreement by my client that he can stay. And that's not something my client is going to agree to. And I made that very clear to Mr. Kelly. Your Honor, with respect to Mr. Kelly's motion and his statement that he has good cause for his failure to appear, he put many things in his motion, Your Honor. I would say the majority of them have absolutely no relevance to the issue of good cause. That is delineated in the response that I filed with the court. And Your Honor, just for Mr. Kelly's awareness, there was a glitch in our system, and the address that I mailed my response to, which it went out day before yesterday, so we probably wouldn't have been delivered by today anyway. It's not going to go to him. So with his permission, I will email him a copy of it if he wants it for his records. I'll stick it in the mail as well, because I do have his email address.
Okay, yes. Well, you have the court's permission to do that, understanding what you did.
I don't have a problem.
Thank you, Your Honor. The specific issues that he put in that I believe have absolutely no relevance to the issue of good cause is that the court being aware of his transportation issue and his having to ride a bike to the court previously, he somehow managed to get here every time. Further, for this specific motion, or excuse me, the trial date, Your Honor, Mr. Kelly stated he had a ride lined up and he chose not to take the ride because of another reason, and we'll touch on that in a moment. But he had a ride lined up and he has a ride today, I believe. My client's here and sees that there's another resident in the community that she believes may have driven Mr. Kelly to court today. So clearly he has the ability to get transportation here. As the court noted, Mr. Kelly didn't call the court And Mr. Kelly made a statement that his phone was broken. But Your Honor, I seem to recall, and maybe I misheard, but in this hearing, when questioned about why he didn't call the court, he said he didn't have a phone. But just a minute before that, didn't he say that his daughter called him about an emergency?
The night
So
before.
daughter was able to call him the night before. If his phone was broken for the 3 or 4 days before that, somehow he didn't have a phone the morning of court to call. But not only that, he's obviously got people in the community that are there to support him. As the court pointed out, he could have borrowed a phone from anybody. So I don't believe that Mr. Kelly has stated good cause. For the additional reasons stated in my motion, Your Honor, he stated his belief that he'd be given a break because default was a possibility, may enter. But Your Honor, Mr. Kelly's been in court before and failed to appear, and a default judgment was entered against him. And I referenced that particular case number in my response. Your Honor, he referenced his concern related to his alleged request for a jury trial, but the court has already touched on that. And Your Honor, the date, just for the record, that that particular issue was addressed was September 20th of this year. He cites an alleged case with the Michigan Civil Liberties Department, and I assume he means the Michigan Department of Civil Rights when he states that. Again, has no bearing on his good cause for appearing at the trial date. That he was finally in touch with an attorney from MI Legal Help. Again, no bearing on his good cause for failure to appear, and that he intends to file appellate pleadings. Again, no good cause for his failure to appear. Your Honor, this emergency with his daughter, I'm sympathetic to whatever's going on in his family situation, but Your Honor, Mr. Kelly has been stating various times throughout these proceedings that this alleged custody issue has interfered or detracted from his ability to meaningfully engage in this court process. And Your Honor, I personally did a search of the Circuit County Register of Actions. I don't see anything pending in that case. My understanding from what's available on that Register of Actions is that Mr. Kelly's ex-wife has sole legal custody of his daughter. And one of the police reports that we were able to obtain from the Michigan State Police, and I believe it's from sometime last year, I don't have the exact date, that there has been no change in that. They specifically referenced that his ex-wife has custody, full legal custody of his daughter, and that there's been no change to that. If there's been some change between 2023 and now, Your Honor, it's not showing on the Register of Actions, but there's nothing pending showing in that case with the Washtenaw County Circuit Court. Your Honor, with respect to this alleged meritorious defense, first off, we've already addressed at the settlement conference before Mr. Kelly was taken into custody for that bench warrant, why additional things were added and more specifically stated in our complaint for termination of tenancy. And that is because the demand that was issued, Your Honor, states reserves the right to bring this and other issues that are lease violations to proceed on the termination action. And so at that court date, Your Honor, which was approximately 3 weeks ago, Mr. Kelly had notice of what additional grounds would be relied upon by plaintiff. One of those issues was an actual admission by Mr. Kelly with a photo he provided to the court of his dog sitting outside on a tie out. Community doesn't allow that. And frankly, Your Honor, the dog was tied out again today. Mr. Kelly nowhere in sight. My client is signed into Zoom right here, and she could tell the court that, again, the dog was tied out. Mr. Kelly was not out there with him. Minor violation of the rules, Your Honor, yes, but it's just a continuation of Mr. Kelly believing the rules don't apply to him, Your Honor. And that's unfortunately been how this process has gone throughout. Every time the court has ordered Mr. Kelly to do something and he didn't follow through, there's just been some reason why he should be given leeway and that he shouldn't be bound by the orders of this court, the rules of the community, the laws of the state of Michigan, Your Honor. Speaking of those laws, Mr. Kelly has still yet to state any defense to his driving in the community, probably since 2017, without a license. The lease that he signed clearly states he is to be in compliance with the laws of the state, local ordinance, federal law. And Mr. Kelly is in violation of Michigan state law by driving without a license in the community. He's been living there since 2017, and I believe he acknowledged at the settlement conference on the 22nd of October that he hasn't had a license since 2017. So that on its own is sufficient grounds for this court to grant a judgment of possession. And I believe Your Honor even alluded to that at the last court date and still gave Mr. Kelly the courtesy of having an opportunity to appear for a bench trial and bring his witnesses. With respect to this alleged retaliation or retaliatory eviction, Your Honor, the statute is very clear on what constitutes retaliation, and Mr. Kelly has yet to cite anything in that statute that my client, that he has done that would bring about a claim of retaliation by my client. But even if he had, Judge, that is a rebuttable presumption. And my client would still have the ability to show that they have legitimate grounds to terminate Mr. Kelly's tenancy. Your Honor, at that settlement conference, it was discussed how Mr. Kelly's answer was deficient for a number of reasons. One of those things being that he in no way addressed the specific issues that were referenced in the termination of tenancy notice, that being the animal loose in the community, disturbing other residents, parking on the lawn, failure to maintain the home and site, verbally abusive towards management. He's addressed a few of those things today, Your Honor, and my client would acknowledge today that certain issues with respect to violations relating to condition of the site were addressed. But as we discussed at length at the October 22nd hearing, Your Honor, with respect to the vehicle, it sat there for months after violations. And Mr. Kelly didn't do anything about it. My client had to ultimately have the vehicle towed. So there's a violation right there that there's clearly no defense to. With respect to the verbal abuse of management, Your Honor, how do you cure that? You can't go back and take the words back. I mean, it happened. So that's not really a curable thing. With respect to disturbing other residents, that's something that continues to happen.
That's not true. I mean, that's just a statement.
Mr. Kelly, I didn't interrupt you.
Oh, I'm sorry. I can't talk. I thought you were done. I'm sorry.
You will have an opportunity to respond. But Your Honor, we talked at length on October 22nd about how Mr. Kelly's answer was deficient because it didn't address those things. And in filing his motion, Your Honor, he still doesn't address those things. The only things that he brings up is this alleged audio recording that he thinks will prove retaliation. But that's not going to be sufficient. The statement that he's provided does not give any detail, which is the issue that was precisely stated at the hearing on the 22nd. And Mr. Kelly is still not following the rules and now expects the court to give him leeway again. The court has already done that by setting the matter for a bench trial on the 30th. Mr. Kelly's own motion, Your Honor, clearly states, I made the decision not to come to court because I didn't want to bring my daughter. He made a calculated decision based on the circumstances not to come to court. And he has not set forth anything in his motion that should change that outcome. Respectfully, Your Honor. And so I have to ask that this court deny his motion and allow the judgment to stand.
Your Honor, I want to address the motion itself. She had brought in I meant to put that under the ex parte where I marked the money to go into escrow.
But there was no escrow filed.
No, there wasn't, but there was a box. Your Honor, when I was before you, it was, you know that I have money problems. I have a fixed income coming in every week, every month. And when that comes in, I can pay any arrearage. I mean, and that's what I was speaking to when I met the demands, when only in the money, I wasn't talking about here, but when I went before you, I've been going before you for the last 4 or 5 months before the just cause. And what I was saying was that, you know, when you said pay on this date and the court said we did, except the one time when I was $43 short, which she'll probably bring up. And regarding the settlement agreement, I was going through these. In fact, I was on the car on the lawn discussing it and speaking to you, Your Honor, when you discovered the warrant thing, and then I was taken out. And when I came back, we didn't discuss anymore. So, I mean, I don't know how I can address it better than that. We were addressing it and going down the list, but then I didn't, I didn't get to, but, it's kind of hard. I'm trying to follow her. Some of these things, she says that in my answer, I don't explain things. It's kind of general. Well, this stuff doesn't either. It just says that, she's stating that the abuse and threatening of staff, I have yet to hear, what are you talking about? I mean, we can all throw out things out there, but what did I say? Who did I say it to? What was it? Because I can remember that conversation and the incident because that coincides with the electrical cord. So, I mean, I mean, these are kind of vague too. I don't know how to defend them, but there is the reason there's a civil right, and I did put the letters wrong, but as far as the Michigan Department of Civil Rights, that I do have a case number or a complaint number, and that's for the very reason that I've been trying to explain to you about the differences in her, her writing me up, or the landlord or the property manager writing me up and not writing the neighbor up for the exact same thing. I mean, that's listed in discrimination by the state of Michigan. I read it, and it uses an example like that. Like if you have a resident here or a tenant here that is late for their rent, and you go in and make a move on them, but across the street is the same exact thing. They're late on rent, but you don't there. That's a civil infraction from what I've read, or it's discrimination. And that's what's going on here. That's why I kind of brought in, sent those pictures to you. I mean, and as far as the day I missed, that was a terrible week. It was my responsibility. I say that in my motion that I got cuffed and thrown in jail. But, I get home and I'm on this website that I've never seen before. My daughter brings it in, and it's you, and it says contemptuous defendant goes out the back door. And gosh, the comments were brutal. I mean, brutal. It's not up anymore, but it was, and my daughter actually answered to some of it. So that week was just brutal. But I said that about my daughter because and the neighbor that drove me here, he's left, so I'm stranded again. But he will attest that we were he was my ride. He usually is. And his car's in the driveway right now. It broke down. And I did try to get other rides, but everybody's at work at that time of day. So what I meant in that was I did have my daughter. If I do get a ride, I got to take her. I wonder if
you said you had made a decision not to.
Well, only because I didn't know if it was allowed at the court.
No. You're telling me you had this and this is what you would have done. But your motion says you had made a decision because of your daughter not to come to court. You can't have it both ways.
No, I know. I explained before that what I was going to bring her, Your Honor. That's what that meant. But I said I don't want to make you mad again because I didn't know if minors were allowed in here. I mean, it explains that before that. I mean, she wants to, she's 13. She wanted to make a statement to you about it because it's kind of her house. But that's not what I meant by it. I take her everywhere since she was born. I have no qualms bringing her, but I meant that because I tried to find rides. We couldn't find a ride with the neighbors. They were all at work. John's the only one that can give me one. Car still broke down in the driveway, Your Honor.
Your Honor, may I respond?
Go.
Please.
Keep going, Mr. Kelly, whatever you want to say. I mean,
I can tell you where it's going, and I'm not an expert.
You can't tell anything about it.
Okay, maybe you're right. I'm sorry. But this is very tough to just present it in a professional way and say it as I mean, but that's honest. I mean, I was trying to get a ride here, but that was the final decision. So I don't get a babysitter for her and go hitchhike down Michigan. I just said, since she's here, that was just meant that I made that decision after I couldn't find a ride. But I haven't skipped your court dates. I'm not looking to, I'm looking to save my house. I mean, and it's not necessarily,
Mr. Kelly,
it's not necessarily to stay there, Your Honor.
Mr. Kelly, I'm gonna stop you because
Okay. May I say,
you just sat here, tried to tell me some story about that you were going to appear. I'm going right to what you filed with this court.
okay,
I have good cause for my failure to appear. I did not appear / answer because, I did not go to the court because I had an emergency hearing regarding my 13-year-old daughter the night before. Says nothing about you actually bringing her. Says nothing about her coming to the court as though you just represented to the court. You didn't come because of her.
may,
I'm done.
I don't have it by memory. Your Honor.
I'm so done.
Please, Your Honor, I just want to.
Mr. Kelly,
You're gonna tow my house away with all my possessions? Not you.
Mr. Kelly, I am going to follow the law. I've listened to you all day and you keep going back and forth in some of these things. But I'm ready to rule. I've listened to the plaintiff. I've listened to you.
Please give me a trial, Your Honor. Please.
All right, Mr. Kelly, I gave a trial date for the parties to be here. It should be noted, although plaintiff didn't say much about it, plaintiff was here with all of their witnesses waiting for you to appear. Everybody interrupted their day.
I know.
They were here ready to go and you didn't appear. And quite frankly, from the court's perspective, the court doesn't hear from you for a good 9-10 days after the trial date. Don't hear anything about what happened, this, that, nothing.
Sorry, Your Honor.
No, you don't have to be sorry. I'm just saying, you're distorting what has transpired. Plaintiff was here, ready to go, ready to, I'm presuming, state with specificity, have testimony and evidence regarding every one of their allegations. You do not appear. Your notion that you've been following the direction of the court, not true. I had to beg you to get an answer into me. I finally got that to happen, told you to pay escrow, you didn't do it, and then still didn't comply with the escrow issue. You may have your reasons, but don't say you followed the direction of the court when you didn't, and you know you haven't.
I guess I should say I tried my best.
You know
I'm
what,
sorry.
Mr. Kelly, I have listened to you all day.
Right.
Now is my turn. I do not want to be interrupted. So for the reasons, part of the reasons regarding your, as I've indicated, there are two prongs you have to satisfy. One is you had good cause for not appearing. You have by no means established that you had any good cause whatsoever from appearing on that date. Now, you make it sound regarding your arrest on the bench warrant as though somehow or another you were manhandled, put in jail, locked in a cell, way down. Let's be real about what happened. You got locked up because there was a valid bench warrant out of 14A4 district court. My court, but handled by another judge. That judge, as I told you, happened to be here that day. We took you into custody. I spoke with her to make a determination as to what to do. And one thing you never said about it, ever, because you're just trying to create sympathy, is you were released that same day. Told what your trial date was, told everything, and you were released without having to post. In fact, when you came back, I arraigned you on the bench warrant and gave you the date to go appear for your driving while license suspended. So don't make it seem like somehow or another this evil judge all of a sudden locked you up on a driving while license suspended and just left you sitting in jail, and that
Because of that, you could barely get yourself out of jail and then appear for trial. That's not what happened. Do not interrupt. And then you sit here with these meritorious defenses or whatever you're trying to claim are defenses. I agree with plaintiff. You have not established any of those defenses, particularly the one you keep trying to harp on, which is the retaliatory conviction. There's a predicate before you can even allege that. You've not even gotten there. Nothing you've alleged is even close. So you don't even have to go through a further analysis of it. You haven't started that type of action against the plaintiff. You've not stated it and haven't shown anything regarding that. The cold-hearted reality regarding the meritorious defenses is, and this is just the reality of how it works, plaintiff would have to just show one, and it could lead to your termination of your tenancy. When you place yourself in this position, you have to show me a meritorious defense to all of their claims. You failed to do that. I honestly don't believe that you've established even one, but you certainly have not established any defense whatsoever to any of these claims. I'm done. You just haven't established. And so for those reasons, your motion to set aside the default judgment is denied. The court specifically finding that good cause nor meritorious defense has been established. The judgment will stand, the writ of restitution will issue. Because the writ of restitution is issued and there hasn't been a written answer filed to the motion to remove the manufactured home and the time has passed, the court will also sign that order and grant that plaintiff's motion regarding that. I am.
All my
Thank you.
stuff's in there, Your Honor. All my daughter's stuff, the neighbor's stuff. And my equity in the home. I want to say thank you that day. I did say thank you. It's on the record for you letting me go home that day I was caught. I was very grateful for it, so.
Your Honor, I believe I submitted proposed orders for both, an order denying
Yes.
attendance and a motion, and an order granting our motion.
And I have signed that order. I have signed the writ, and I have signed your order regarding the removal of home.
Thank you, Your Honor.
All right, thank you. Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm
The
terribly.
behavior from him, from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess. People having rested. Any witnesses for the defense?
No, Your Honor, thank you.
All right, very good. Parties prepared for closing argument? You may proceed.
May I move the question?
Depends on where you want to put it, but yes, you may go. That's all right. That's
Thank you. Good afternoon. When we started this morning, I let everyone know what I expected the evidence would show. Started talking about that Rocky Isley was a nurse working in the jail, and on that date, the defendant was incarcerated in the jail. Talked about how we were going to hear from different witnesses about the defendant reporting to experience a medical emergency. We've heard from 3 different witnesses. First, from Officer Naveen, talked about how that was his assignment that day. The defendant had been upset that day. He talked about how he was upset even earlier in the day. He understood that the defendant was upset about something that had happened before Officer Naveen had even gotten there that day. We heard that he cannot ignore anyone's request for a medical emergency. Because Officer Naveen, Officer Tweedale, and Nurse Rocky Isley have a responsibility to make sure that the people in the jail are safe. That's their job. The corrections officers are there to make sure that the folks who are in the jail are okay. They don't make the decisions about who goes there. They don't make the decisions about who leaves. Their responsibility is safety. Officer Naveen is talking about how he checks every 15 minutes, make sure the people that are in his cell block are okay. He talks about how he makes sure Mr. Bloom is okay. Nurse Rocky tells you about how it's his responsibility when someone says they're experiencing a medical emergency, he doesn't care how old they are. He doesn't think something's more or less likely based on their age. He doesn't think something's more or less likely based on who they are. He is there to make sure they are okay. Officer Tweedale is the one who speaks to the defendant and says to him and gets him to calm down enough to be medically evaluated. Why? Because it's his job. That's his job. He's got to find a way to communicate with each person to help them. Nurse Rocky, I'm sure everyone has experienced a nurse who made you feel safe, who made you feel cared for and listened to. And Officer Tweedale, when this is going to go down and he knows that Mr. Bloom has been upset and he knows that Mr. Bloom has been agitated. He told you how he levels his hand above the food slot door just in case. Why would you do that? Just in case. Safe. But the only person out of these four men who didn't care about the safety of another person was the defendant. You're going to get jury instructions in a few minutes that display for you and educate you that the law does not allow sympathy nor prejudice to influence when you are making this decision. You should not be prejudiced against the defendant because he was incarcerated, and nor should you be sympathetic to him because he was incarcerated. The law requires an examination of the facts, and the facts are simple. The facts are the defendant was in the jail in Washtenaw County. The facts are that the defendant said he was having a medical emergency. The facts are that earlier in that day, he'd been very upset. He was not allowed to get out of his cell. The facts are that he was a level 1 security. The facts are that he had to be medically evaluated through his food slot. And the facts are that when he was being medically evaluated, he yanked his arm back in that food slot, and that slammed Rocky Isley into his wall, or into his door, rather. Now, I can't tell you what defense argument there might be, but I will tell you that you've seen a video, not my favorite angle. You've seen medical records, and you've got a copy of Rocky Isley's own statement that he made on May 31, the day after this happened in the night, about what happened. Everyone has a right to be safe at work. Everyone has a right to be safe in homes. All of the witnesses that you've heard from today helped to keep the defendant safe at his home. His home he didn't choose. He didn't choose to be in the jail, but that's where he was. Each of those men told you how they made a choice to keep him safe, despite his behavior, despite his
Bondi, stop for a moment.
I'm sorry,
I apologize. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you. Take the jury, please.
Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm
The
terribly.
behavior from him, from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess.
All right.
United District Court of County, Washington, State of Michigan is now back to session on Tuesday, 17.
You may be seated. And if we can bring Mr. Bloom up, please. Court recalls the case of the People versus Jeffrey Bloom.
People.
Good afternoon, Mayor Sam Bernstein with and on behalf of Mr. Bloom.
And as I've apprised counsel, during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that at least for these purposes that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings. That then, when Ms. Lundy got up to give her closing argument, there were additional comments. I didn't do anything about that, but the moment the gyrations with your hands occurred behind her back, I stopped the proceeding. I'm not going to tolerate any of that. I will stop it again if that's what we have to do, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition, Mr. Bernstein.
I was going to say there were some times where Jeff was speaking with me during the trial.
Oh, I understand that, but there were other points at which there were just extraneous comments. So I was letting those go, but I'm not going to have that and have counsel interrupted during the course of their closing arguments. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court. They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury. What is going on? All right. Go ahead. Thank you.
So hot mic.
Oh.
Is he ready to, what's? Pardon?
I don't think he wants. Sick, Your Honor.
No.
Yeah. Did you want to go back there and try to talk with him? Because in the record should reflect, if it doesn't already, that after the court's admonishment to defendant and asking whether or not the people in defense were ready, that the defendant on his own accord decided that he would leave the courtroom. I've been informed by transport that it appears that he does not wish to come back out.
I really should try to speak with him, Your Honor. I mean,
yes, you should.
It's a significant right to be at your own like in the Constitution or something.
One which one can, I believe, voluntarily forfeit.
That's fair too. Yeah.
So before we get to that stage, why don't I'll stand in recess and allow you to have an opportunity to chat. All right, thank you.
All right.
Ladies and gentlemen. Yeah, Alan's trying to put the jury out, so. All right. Okay, we're back on the record. Court does recall the case of the people of the state of Michigan versus Jeffrey Bloom. Counsel, state your appearances.
Ashley Lottie for the people.
Sam Bernstein for Mr. Bloom, Your Honor.
All right, Mr. Bloom is not present. If I say anything incorrectly, please, counsel, correct me. Just prior to our last recess, when we were trying to continue with the trial, after the people had begun their closing argument, I stopped the proceedings, gave an admonishment, had the jury gave an admonishment to the defendant regarding comments that he was making, as well as gestures in terms of his hands because of the positioning of the podium behind the prosecutor's back. Gave him that admonishment, then told him that I would not tolerate any of that behavior. At that point, I did not hear anything, or at least nothing that was audible or understandable from the court in terms of the defendant saying anything. The defendant got up and he removed himself from the courtroom. Transport took him back. I took a recess in order to allow Mr. Bernstein to speak with his client. I was then informed during the course of that from transport that Mr. Bloom did not wish to return to the courtroom. And so that's kind of where we were left. The question that arose as to whether or not this court, given the defendant's behavior, whether or not this court could continue with the trial, even though we just had closings and the verdict to go. Out of an abundance of caution, after speaking with counsel and the court looking up for some guidance in this regard, the court did find me, I think it's Rule 43, I didn't bring my copy out of the federal rules, which specifically address the issue where a defendant removes himself from a trial in the middle of the proceedings or doesn't elect to participate. I did not see a rule specifically in the Michigan court rules governing that. As I did a brief research in trying to find cases, the case of the people of the state of Michigan versus Jerry Oliver Swan, that being 394 Mich 451, came to light. It was a 1975 case, so it's a little bit old, but it still looks to be good case law. I gave that to counsel, asked them to take a look, see if we could, between all of us, make a determination as to what would be the best way to proceed. And granted, I don't think anybody's had an opportunity to do any extensive research on it. However, I would indicate that if nothing else, the Swan case is illustrative of a point. And the synopsis basically indicates the Supreme Court held the defendant did not reappear in the courtroom after a mid-trial recess, had not reappeared 4 days later, and testimony was received regarding attempts to locate him. Trial court properly proceeded with the trial with receiving, part of the testimony in the jury's verdict in the defendant's absence. Taking that
without anything else in front of me as sort of a guideline. The court believes that the defendant has indeed conducted himself in a fashion where he has made himself absent mid-trial. It seems to me that what the Swan case seems to point to is that an opportunity be given where this defendant being in custody, we don't have to locate him, but at least an opportunity to be given to the defendant to come back and voluntarily participate in his trial. Having said all of that, after speaking with counsel, the court has made a determination to adjourn the remainder of the jury trial. We are adjourning it to September 30th, 2024 at 10 a.m. For closing arguments and final instructions to the jury. During that week period in time, in essence, the court is giving an opportunity for the defendant to reconsider his decision. Also to allow his counsel to potentially have a conversation with the defendant as to what may be those implications of him having removed himself from the proceedings. But I think in fairness, and since they are monumental and rights that the defendant would be forsaking in terms of leaving his trial, the court thinks that it would be prudent for the court to do so. That was long, however. Either counsel have anything to add or to say contrary to what the court has indicated on the record?
Nothing contrary, Your Honor.
Neither for me, Your Honor.
All right, very good. And I do appreciate both counsel being patient as the court was trying to think through this and also participating in trying to find something that would guide us. It was really truly appreciated on this court's behalf. So this matter is adjourned to September 30th, 2024, 10 a.m. for continuation of the jury trial. Thank you.
Thank you, Your Honor.
I should, don't go off yet. I should also know one other thing. The people had requested that I give to the jury an instruction to not talk to anybody, same instruction that I had given them during the opening statement, but just to reiterate that to them. And the initial thought was to bring them back out, give them that instruction, and then have them go. And I think it was correctly pointed out that Mr. Bloom not being present here may send some signal to the jury. I assured counsel after they had indicated that they trusted the court to give that instruction to the jury. I did do so. They each acknowledged that they understood that instruction before leaving. So
thank you, Your Honor. That's accurate. People wanted to be sure that they very understand that those not talking to people and all those risks do continue during this adjournment. I appreciate that. Thank you.
yeah, thank you, folks. I think that's it.